Hey everyone. Welcome to today's Lunch and Learn. It's great to have you here with us. We are very happy to have our Litigation Unit Assistant Attorney General, Paul Spruan, joining us today. Paul leads a lot of our high-profile federal court cases as well as Navajo Nation cases. And so we're excited to have him here with us today. His speaking services are on high demand with the law programs throughout the U.S. So we're fortunate to have him here on our team and to be able to have him representing the nation's interests in our various litigation. And I'm the Attorney General, of course, as many of you know, and I'm happy that we're starting this year off strong with our Lunch and Learn series. So, but Paul, I'm going to go ahead and hand things over to you, and then at the end I'll pop in for to help with the Q&A. So, thank you.
Thank you so much, Attorney General. And can you hear me? I will assume that you can. Paul Spruan Yin. As Attorney General Branch indicated, I'm Assistant Attorney General here at the Navajo Nation Department of Justice. I'm here in Window Rock, and I'm the head of what we call the Litigation Unit. Now, you had, if you have been following this series, a presentation on employment law a few months ago with several of my staff at the Litigation Unit, Louis Millette and Colleen Silversmith. Employment, we do a lot of that here within the Litigation Unit, but I'm going to talk about the other aspects of what we do. And as Attorney General Branch has indicated, federal litigation. Now, we do litigation within the Navajo Nation court system. We do some state work, but we do a lot of work in the federal courts. And what does that entail? What exactly does the Navajo Nation Department of Justice do? Well, on behalf of the Navajo Nation, which is bringing cases for the Navajo people in a number of different areas, sometimes we're the plaintiff. So, for instance, if you've been following over the years, the Navajo Nation sued Urban Outfitters, got a successful settlement out of that, sued some opioid manufacturers and distributors and public relations companies dealing with the way that they have dealt with opioids and have received some funding on that. Gold King Mine, if you recall, the spill from Colorado of the Gold King Mine created by contractors of the United States Environmental Protection Agency, and of course mining companies through the legacy of Gold King Mining. The Navajo Nation sued and has successfully received settlements for pretty much everybody except for one or two holdouts. Wells Fargo, the Navajo Nation a few years ago sued Wells Fargo based upon some activities that Wells Fargo was conducting as it relates to inducing people to open checking accounts and other matters. Got a successful settlement out of that. So there are a number of times, also as you may have heard, San Juan County, New Mexico, San Juan County, Utah, in voting rights cases. And very recently there was a lawsuit involving the way that San Juan County, New Mexico created the map dealing with county commission districts. And San Juan County, pursuant to that lawsuit, voted to change the map in a way that will create two districts wherein Navajo majorities are able to elect candidates of their choice. Up until that point, there was only one county district that you could say that for, and that was under the Voting Rights Act. So there are a number of federal laws in federal court that the Navajo Nation, through the Department of Justice, with us and also sometimes with outside counsel when we need certain assistance, depending on the sort of complexity of the matter, will file on behalf of the Navajo Nation, on behalf of the Navajo people, to sue various entities, governments, corporations, whatever, to attempt to get them to remediate whatever it is that they were doing that was detrimental to the Navajo people. Sometimes we're the defendant. Sometimes the Navajo Nation is sued by various parties in federal court. And there's various times that might happen. One of the major instances where that happened is where a non-Indian has been sued by someone in the Navajo Nation courts, let's say the Labor Commission for violations of the Navajo Preference and Employment Act. And they argue that the Navajo Nation doesn't have the sovereign authority to do what it is going on. So attempting to enforce the Navajo Preference Employment Act, or taxing, or a tribal court matter involving a car accident where the insurance company doesn't want to have to be a defendant in tribal court. There's a matter that's ongoing in Chin Lee involving the Pick and Run gas station. If you know Chin Lee, it's right there in the center of Chin Lee, where there was a gasoline spill underground at that gas station in 2005. And that matter is still being litigated by the Navajo Nation, by the Department of Justice in the Chin Lee District Court. But several of the defendants' insurance companies refused to subject themselves to Navajo Nation jurisdiction, and therefore argued in the tribal court they weren't subject to the nation's sovereignty, and then went to federal court. Because no matter what we think, the Department of Justice, the Navajo Nation, our Navajo Nation courts, the federal courts have said, if you think that you are not subject to tribal jurisdiction, you can sue in federal court, and the federal court can enjoin our tribal judges, our labor commissioners, the president, whoever it may be, because they claim that federal law limits the authority of tribal sovereigns over, and it's usually non-Indians. It's usually a non-Indian who believes and accesses U.S. Supreme Court case law to say, okay, Navajo Nation, you're not really a true sovereign in the sense that I am a non-Indian and I can't vote in this society, so you cannot subject me to your law. That is actually a series of cases that the Department of Justice has had to litigate, mostly successfully, sometimes not. For instance, in 2017, there was a case involving the Window Rock Unified School District that went all the way up to Ninth Circuit Court of Appeals in San Francisco. And then the school district tried to go to the U.S. Supreme Court because they asserted that as a state public school district, they were not subject to the Navajo Preference and Employment Act, and therefore they could not be sued in the Labor Commission for a wrongful termination for whatever it is. They claimed essentially absolute immunity from any regulation by the Navajo Nation by virtue of the fact that they are a school district organized under the laws of the state of Arizona. Now, mind you, they had leased tribal trust land from the Navajo Nation. And for those of you who are aware of the Window Rock area, there is the elementary school here, formerly TDB, down the road from the president's house. Up in Fort Defiance, there's 4 or 5 different parcels where the basketball stadium is, the high school, teachers' housing, the administration building with the other intermediate learning center. And then, of course, the legacy in the middle of Fort Defiance, where the football stadium is, where the middle school is, where more teacher housing is. All of those are on sovereign Navajo Nation land. And yet, the Window Rock School District made the argument that, in fact, they were not subject to Navajo Nation jurisdiction. Now, the Ninth Circuit said, due to this, the Treaty of 1868, this is, of course, the most famous rendering of the signing of the Treaty of 1868, the Navajo Nation has the right to exclude non-Indian entities and therefore the right to make them follow our law. Now, that wasn't a definitive decision. It went back and it is currently pending in the Labor Commission. Still, as to whether or not definitively the Navajo Nation has the right to regulate employment at these state public school districts. And this isn't just going to affect Window Rock, all the other school districts, which are state public schools, Chin Lee, Kayenta, Tuba City, etc. On the New Mexico side, of course, there is Central Consolidated School District and Gallup-McKinley School District, which operates high schools, elementary schools within the Navajo Nation, but again, are state public school entities organized under state law. So that's an example of this sort of concrete example of the kind of things that we face all the time. Because whether we like it or not, we have to answer a lawsuit in federal court when they file it against our Supreme Court or our labor commissioners or the head of the Office of the Tax Commission. And we have to argue through federal law why the Navajo Nation has the sovereign right to adjudicate, to regulate, to make anyone who is present within the Navajo Nation subject to our laws. And it's a constant fight. And there's no real ending to it. So every 3 years or so, we get, a complaint in the mail saying, by the way, your government officials are being sued in federal court by so-and-so, and you need to file an answer within 20 days, which we do. And it goes all the way up sometimes to the United States Supreme Court for us to defend our sovereign right, your sovereign right as the Navajo people for self-governance, for self-determination, to decide that everyone within the Navajo Nation is subject to Navajo Nation law. Now, I wanted to talk about a few Supreme Court cases. The U.S. Supreme Court, of course, the highest court in the land that decides what federal law is, that have affected the Navajo Nation. Some of them were a direct party. Some of them we were involved by filing various briefs, what we call amicus briefs, friends of the court brief, where we assert our sovereign rights through these briefs, but we're not a direct party. And then some that we haven't been involved in, but it nonetheless affects what we do, right? And so I had given a presentation maybe about a year ago when these lunch seminars started about 3 different cases that at that time were decided by the U.S. Supreme Court. And of course, there was the Holland versus Brackeen case. And as a refresher, that is, of course, about the Indian Child Welfare Act and whether it is constitutional, whether the Indian Child Welfare Act passes constitutional muster. And of course, for those of you who have heard of it, you know what it does. It creates very significant, important protections for Navajo families in state court when a child is picked up by a state child, youth, family services, and then it goes before the court either on a delinquency or abuse and neglect or whatever. And under what circumstances can the state take that child and put them someplace else? And if they put them someplace else, either temporarily or facilitating an adoption, who gets the first opportunity to take care of this child? And that is one of the things that was attacked directly in the Indian Child Welfare Act, because it says first it should go to a member of that child's family, foster care, adoption, whatever. If someone in that immediate family is not available, then it goes to another Navajo. Then and only then, if there's no other Navajo, it goes to a family of another tribe. Isleta, Ute, whatever, whoever is available. And then and only then can a non-Indian be a foster family or an adoptive family. And so the Brackeens, who were looking to adopt and did adopt successfully at least one Navajo child, filed with a number of other people, including the state of Texas, the state government of Texas and Louisiana and Indiana, saying it is unfair to treat Indian children different than non-Indian children and to treat us as a non-Indian adoptive family differently because we are not Indian. And one of the most serious arguments in that case is when Congress legislates for Indian tribes, creates a beneficial statute that says, like the Indian Child Welfare Act, an Indian tribe has the right to participate, an Indian tribe has the right to intervene in this case. You can't break up an Indian family unless you go to this very high level of proof. Is that a racial statute or not? Is Indian status a race-based status? And this is important because the U.S. Supreme Court, particularly this 6-3 conservative majority over the last 10, 15 years, has said even legislation that's beneficial for that particular minority or racial group still violates equal protection of non-Indians, or in this case, in other cases, white people, because it treats them differently. And if you treat them differently, you have to have a very important reason to do it, which is almost impossible to fulfill. Now, that was an issue, went all the way up to the U.S. Supreme Court, but the U.S. Supreme Court didn't decide it on that question. They basically said, well, you shouldn't have brought that particular claim, Brackeen, state of Texas, so we're not even going to decide it. What they did decide is that Congress had the power to do this, generally speaking, okay? And it doesn't violate the sovereignty of the states to make the states follow these requirements in ICWA. But what was left open? What's still out there? What's still floating out there that is unresolved? This issue of when Congress says Indians have these rights, we recognize these rights and benefits for Indian people, for members of federally recognized tribes of native nations. Is that a racial distinction that is unfair to non-Indians and therefore violates equal protection? So we don't know. We don't know what this current 6-3 conservative majority thinks about that. What we do know is what they think about affirmative action. And I want to talk about that case, even though the nation was not a party to that case. And it's called Students for Fair Admissions. And so you may have seen in the news that Harvard and the University of North Carolina had affirmative action programs that through the way that they dealt with admissions when you file your application, they gave some credit in their assessment system to the fact that you were a minority candidate, right? And so Indians or Native Americans or whatever you want to call it are among the group of minorities that benefited from this program and how they viewed admissions. And the argument was by this organization that is a race-based unfair violation of equal protection because members of races that are not these minorities are detrimentally affected, that they're negatively affected by the fact that they don't benefit from this additional assessment within the admission system. And of course, there's all sorts of anecdotal stories about, well, I'm white. If, I applied to 5 different colleges and I was rejected and it's because I'm a white person and that's why. Okay. Whether that's ultimately true in those individual cases or not was unimportant to the court. What was important to the court is they believed that the way that Harvard and North Carolina were making these assessments did violate equal protection because it was an unfair racial classification. Now, why do we care about that? Well, it's because American Indians were one of the groups that were considered racial for this purpose, and the use of it violated equal protection. So my son, who is a tribal member, goes to the University of Arizona, and there are various programs, of which I'm sure your children, relatives, whatever, have also been part of these college programs. There are certain scholarships that apply within these colleges now for Native students. Are those vulnerable? Are those going to be attacked under this particular lawsuit? It's entirely possible. But because there is this argument that was not decided by the Brackeen case about the Indian Child Welfare Act, that when you define Native Americans by being members of sovereign tribes, that is not a racial distinction. It's very different than if you're talking about African Americans or Asian Americans or Hispanics or whatever. Hispanics is a little different because it's not technically a race. But is there something different, meaning that Indian programs in colleges, both for admissions, scholarships, and otherwise, can survive even if affirmative action, broadly construed, is now considered illegal? And so that's coming. And that is something that we at the Department of Justice for the Navajo Nation, for the Navajo people, will be looking into. And I suspect that we will very much actively participate and put forward the argument that, in fact, these are distinctions based upon the sovereign status of the Navajo Nation. Therefore, if you are an enrolled member of the Navajo Nation, that is not a racial distinction. Therefore, these programs will survive. But that is an open question that was not resolved by the U.S. Supreme Court as to, is Indian legislation inherently political? Or are there sometimes, depending particularly on how they define Native American, American Indian, that it is like a affirmative action benefit, so-called, for other groups like, say, African Americans or whatever it may be. Now, some of you, and there's been a lot of discussion in these programs about water rights, about what's been going on in Arizona, what's going on with the Colorado River. Of course, there's been numerous newspaper and other articles about climate change and the scarcity of water, and what is it going to take to get clean, reliable drinking water and other types of water to the Navajo people. Okay. Now, as has been discussed, there was a case in the U.S. Supreme Court called Arizona versus Navajo Nation, not just a clever name. It was about Arizona and the Navajo Nation, but it was also primarily about what responsibilities does the United States government, particularly through the Department of Interior, have to facilitate water development on the Navajo Nation? Because if you missed the last discussion, but just by the mere vocabulary that we use around here, trust land, the trustee. The United States government has taken upon itself this responsibility, but also power to decide what happens on Navajo land, that it is all in trust or primarily in trust, whether it's an allotment or trust, so-called trust land or not. And therefore, they have historically controlled practically everything, particularly before 1975 or so, when the so-called 638 law then had contracts where our social services department, health, police department get federal money to actually operate these programs. Up until that point, it was almost, other than the police department and our courts, the BIA, the Bureau of Indian Affairs, was doing everything because of this alleged authority arising out of this thing we call the trust relationship. And you go back and you go way back and you go into the mists of time. And so much of Indian law is affected by what happened 100 years ago, 150 years ago, 200 years ago, and still living with the legacy of that today. And that's true here too. Because where does this trust authority responsibility come from? Well, the United States Supreme Court in the 1830s, in a case called Cherokee Nation versus Georgia, Justice John Marshall, Chief Justice John Marshall said, I don't really know what the relationship is between Indian tribes and the United States. They're domestic dependent nations. That's the actual term that he came up with. Oh, and the relationship is like no other in the world. It is like a guardian to its ward. And of course, a guardianship is usually when you have a minor or someone who has a mental issue or someone who cannot take care of themselves. And that's what the United States constructed the entire reservation system based upon that belief that they're the trustee, they're the guardian, and Indians cannot sell their own land. They cannot manage their own money. We'll do it. Trust us. It's in the name, trustee, and we'll take care of you. Now, what happens if they mismanage the land? What happens if they mismanage the money? Oh, I don't know. It's somewhere. Look under the couch. There's some change. Yeah, I don't know what we did with it. It's somewhere in the treasury in some account somewhere. No, we can't tell you what we did with it because, I don't know, there's a bunch of paper. It's in some cave in Kansas somewhere, but, we'll get to it someday. What if the Navajo Nation says, oh, no. Oh, no. Oh, no. That's not good enough, United States government. You need to account. You need to tell us what you've done with this money. You need to tell us what you've done with the forests. You need to tell us what you've done with water development. Just throwing that out there as an example. Can we sue the United States government in federal court and demand that the court order them to do something because they have violated this trust responsibility? You wanted this trust authority. You wanted this power. So when you misuse it, we get to use the federal courts to make you make it right. That was the premise of this case. It went on for 20 years. It was filed in 2003. And it was really Navajo Nation versus Department of Interior. Why was it called Arizona v. Navajo Nation in the U.S. Supreme Court? Arizona and a bunch of other people intervened in the case. So they're not the original party. Navajo Nation versus Department of Interior. You can come in as a non-party and say, I want to be a party to the case. And the Navajo Nation does that all the time. So then when it went to the U.S. Supreme Court, Arizona jumped the line and they went to the Supreme Court first before the United States. So the way the Supreme Court does it is whoever gets there first, that's the name of the case. So it was Arizona who came in first versus Navajo Nation. Then the U.S. came in later, but they consolidated the case. So now it's called Arizona versus Navajo Nation, which is so strange because it's about the federal trust obligation to the Navajo Nation. What does Arizona have to do with that? Justice Gorsuch, at the oral argument, looked the Arizona attorney in the eye and said, what is your interest here? What is it that you think the problem is for you that you're here in this case? Sorry, Your Honor, I see my time is up. Right. Because really, this was the Navajo Nation attempting to get Interior to take seriously our water rights to the Colorado River. And there's an entire history behind this that really, in the time that we have, can't really get into it, but read Justice Gorsuch's dissent in the case because it lays it out. So the point of it is when the United States intervened, dropped in as a party, in a case called Arizona v. California. They were there as the trustee, raising claims for Indian tribes to the lower main stem Colorado River. Who did they not make a claim for? The Navajo Nation. The Navajo Nation said, whoa, hold on a second. Are you going to make a claim for us or not? U.S., no, we're not. Oh, okay, fine. The Navajo Nation tried to intervene separate and apart. The U.S. said, wait a minute. We're the trustee. We get to litigate this because water is a trust asset. Navajo Nation doesn't have a right to come in separately than us and tell you what their claim should be. And what did the special master in the U.S. Supreme Court said? Yep, that's right. Sorry, denied. Therefore, there was no adjudicated claim when the decree came out in Arizona versus California. So this was in 1963 that this happened. So then the Department of Interior, who has, pervasive control over the management of the Colorado River, you need a contract, et cetera, the Navajo Nation was like, well, wait a minute. When you make these decisions, like, look, there's a surplus. Here's how we're going to divide the surplus of the water. Well, wait a minute. What about the Navajo Nation's water rights to the Colorado River? Yeah. That's. Anyway, here's your surplus guidelines. So the Navajo Nation said, wait a minute. At the very least, when you do these things, you need to consider the Navajo Nation's rights to the water in the river. And the U.S. said, no, we don't. You can't sue us. You can't establish a breach of trust. Why? There's no specific express obligation that Congress has told us we have to do. So you cannot make us do anything. That was the United States claim. Went all the way up to the Ninth Circuit. The Navajo Nation won in the Ninth Circuit. This was during the COVID pandemic. Oh, no. There are reserved rights, Winters versus United States, that the Navajo Nation has. There's a treaty wherein the United States promised to provide seeds and implements and other things that need water. And then you control the entire access to the Colorado River, United States government. So how can you say you can't make us do anything? No, the Ninth Circuit said, in fact, the Navajo Nation has shown, as a threshold matter, that they have the right to sue for breach of trust. What happened? Arizona went to the Supreme Court. The United States went to the Supreme Court. 5-4. The Navajo Nation did not prevail on its claims that, in fact, the United States has an obligation to do anything when it comes to recognizing, facilitating, protecting the Navajo Nation's rights to the Colorado River. Justice Kavanaugh wrote the opinion. Justice Gorsuch wrote an extremely well-written dissent that picked up on what we were trying to say in that case, which is our treaty is entirely premised on the idea that the Navajo people were coming back to the Nepakia, to the sacred lands of the Navajo Nation. The federal government was supposed to provide things to us upon the promise that we were going to return to this area. Seeds, implements. They were going to set aside land. When you read the transcript, which I would suggest everybody does, of the negotiation between this guy, William Tecumseh Sherman, general of the Civil War, who burned down Atlanta to the sea in Savannah and then became part of the Peace Commission, who negotiated with the Navajo Nation, and Barboncito and Manuelito and Ganado Mucho and the other leaders of the Navajo people. They had a conversation. It went on for 3 days. And what did Barboncito say? We had corn. There was rain. We were able to grow our crops and feed the Navajo people. And now we're here. And I know, it's a sensitive topic, but I have to explain it for our purposes here. At Bosque Redondo, where all the promises you have given us, United States, have come to nothing. We can't grow anything. The water's terrible. So yeah, we want to go back to our lands, but also you're promising us certain things that you're going to do to help us. Was that sufficient for the U.S. Supreme Court to say, therefore, the United States has a specific obligation to the nation as it relates to the Colorado River? No. Why not? Because they adopted a very high standard from this case called Hickory Apache versus United States. It's not enough to have a trust responsibility. It's not enough that water is a trust asset. Congress had to specifically say, whether it approved a treaty or a statute, you must do this exact thing. And if they didn't say you must do this exact thing, that's not enough. So sure, okay, the United States has a trust obligation. Yes, water is a trust asset, but you can't use the federal courts to make them do anything. Does that mean we don't have water rights to the Colorado River? Absolutely not. Does that mean that it at all affected our claims? No, because it was about breach of trust. In fact, there is a mention in the majority opinion about groundwater being part of the reserved rights of the Navajo people, which is pretty incredible. Because the U.S. Supreme Court, for the first time, now the Ninth Circuit had said something about this in a case involving Agua Caliente, that in fact, groundwater is included as a trust asset for which there are reserved rights when the reservation was created. So where does that leave us? We still have the rights to this water. We still have things to talk about with a number of different people. But this case did not destroy anything. If anything, it was a positive development. And therefore, we are, not me personally, but other people within the Department of Justice, working after this case to take the positive aspects of it and continue to make those claims for the Navajo people that Colorado River water is something that we can use. Now, there have been other federal cases that have been going on of some importance. There was one, this is, sort of a more, arcane area, but bankruptcy. There was a case called Lac de Flambeau versus Coughlin. We were the lead amicus brief. We at the Department of Justice here wrote the brief for all the tribes that was then submitted to the U.S. Supreme Court. And it had to do with when can the tribe be sued in bankruptcy court for things like violations of certain aspects of the bankruptcy code. Now, unfortunately, the Supreme Court said 8-1. Gorsuch was the lone dissenter. Tribes can be subject to the bankruptcy code, meaning that they can be sued. We didn't particularly like this outcome because tribes are not mentioned at all in the bankruptcy code. We would like the rule to be that Congress has to explicitly include tribes if they mean to undermine tribal sovereignty. Now, unfortunately, in this case, because bankruptcy is its whole different universe, they basically said, well, you don't have to say Indian nations or Native nations or tribes as long as it's clear in the language of the waiver that you intended all governments. What does that mean? Well, it's sort of unclear, but the Navajo Nation has many leases, it collects taxes, there are rights of ways for pipelines and other things that a lot of people are paying a lot of money in terms of revenue for the Navajo Nation government. If they go bankrupt, we then stand in line with everybody else, with every other creditor, and get pennies on the dollar. If we attempt to collect, we can be sued for money damages in bankruptcy court for a violation of what they call the automatic stay. Now, there are a couple of other cases I wanted to talk about from the prior term, and it has to do with state criminal jurisdiction, police, district's attorneys, and it's called Oklahoma versus Castro Huerta. Now, this is something that you may have seen in the press. There's been a lot of discussion with state officials about. And yes, it's about Oklahoma. It's not just a clever name. And if you've been paying attention, Oklahoma has a whole different thing going on over there because of a case called McGirt versus Oklahoma, where there was an assumption that there were no more reservations within Oklahoma. Not so. Justice Gorsuch wrote the majority opinion and said, in fact, Congress did not clearly intend to get rid of all of the reservation boundaries in Oklahoma. So guess what? There are reservations in Oklahoma. Governor of Oklahoma is not very happy about that. So then they tried to get that case, McGirt, reversed in a case involving a non-Indian. And this is the important fact. The non-Indian was accused of criminal neglect of a tribal citizen. This child, I believe, was a member of the Eastern Cherokee Nation of North Carolina, but was living within the now re-recognized reservation boundaries of the Cherokee Nation in Oklahoma. Up until that point, everybody assumed when a non-Indian commits a crime against an Indian, only the United States government can prosecute. Now, we don't necessarily agree with that in the Navajo Nation. As you may know, in our criminal code in Title 17, it says if you are married into the tribe, even if you are a non-Indian, hadane, in-law, whatever, you are under the direct jurisdiction of the Navajo Nation. There was also a congressional statute in the Violence Against Women Act that re-recognized the criminal jurisdiction of tribes over certain non-Indians. We have never actually adopted that on the Navajo Nation yet for various reasons. But this was the question, can a state county prosecute a non-Indian for a crime committed against an Indian on the reservation? And Justice Kavanaugh, again, the same one who wrote Arizona versus Navajo Nation, oh yes, of course you can, because states have always had jurisdiction in Indian country. Well, what's this thing about tribal sovereignty? No, they're in the boundaries of the state. So they have the inherent authority to do whatever they want, unless Congress says otherwise. Completely flipping 175 years of law that said states do not have jurisdiction to go in and do whatever they want within sovereign tribal nations. Now, what was the nation's participation in this? We filed a brief about the Treaty of 1868, and we got signatories of various other tribes, Cheyenne River Sioux, Southern Ute Mountain, Crow, that also have very similar treaties from the exact same time period, 1867 to 1868. And we said, whatever your national rule is, it does not apply to us because we have treaties with the United States. And those treaties say the United States has the responsibility to deal with non-Indian bad actors. They're literally called bad men in Article 1 of our treaty and all those other treaties. So the state has no role to play. It remains that the states do not have sovereign authority within our reservation because the United States promised us in the treaty that we would be free from state authority, period. That was the argument. Justice Gorsuch acknowledges that in his dissent. He was the dissenter. So it was another 5-4 decision. Comey Barrett seems to be the swing voter in these things because she voted for ICWA's constitutionality in Brackeen, but then voted against the nation in Arizona v. Navajo Nation, voted against the tribes in Oklahoma versus Castro Huerta. But it's still out there as a position. Now, what does that mean? Does that mean that we don't want assistance from state law enforcement? No, that's not what it means. It means if you are going to come in to the Navajo Nation, you do it with the agreement and understanding with the Navajo Nation, cross-commission agreements, mutual aid agreements. You will recognize our sovereignty and we will define the contours of how you will assist us. Does that mean we don't like additional state law enforcement when crimes are committed? No. Does it mean you need to recognize the sovereign authority of the nation under the treaty when you do? Absolutely. And that's how we have leveraged our sovereignty to make sure that, yes, there's protections for the Navajo people when available for outside law enforcement when they're willing to come in and do it, but on our terms. So that's report is about 1241. I'm happy, AG or others, if there are questions or comments that we can talk about, I'm happy to take any of those at this time. Thank you.
Awesome. Well, thank you so much, Paul. We all enjoy your presentation style and, of course, your grasp of information and knowledge. So thanks for prepping that for delivery. It's quite a talent to be able to convey that in understandable terms. And I think that you're able to do that very well. So thank you for that. And we do have a couple of questions from Carrie. She makes an observation that the relationship, and this was posted at about 12:30. She says the relationship you're describing between the U.S. and the nation is somewhat how I see the nation and its local government entities. I'm hoping we can continue to mentor and strengthen our local entities so they can oversee or govern their people and their areas as they see fit along with their people. And I don't know if you want to comment on that.
I mean, it's an interesting observation. Absolutely.
Yes.
And it's probably you as Attorney General more appropriate as the Chief Legal Officer, but Mr. Begay when he gives Rob Begay when he gives comments on this. So I would say it's definitely an excellent observation, and one that I think can be cultivated through continued discussions between local governments and the Navajo Nation, for sure.
Definitely. And Rod does have a proposal for government reform that he's been working on for a while, and that political leadership at this time has a high interest in, namely the president. And that would allow for more robust governance at the local government level. Certainly, it would be helpful to have more delivery of services at the local level to ensure that the needs of the people are being met. But so Carrie, thank you for prompting that conversation. And then she has another question, and I don't know how much we want to go into this, but it's a good question.
I will answer. That's a good question. No, I'm just kidding. Go ahead. Yeah, but what's the question?
She's asking about the history of our boundary with respect to the Colorado River and the Grand Canyon. And she says, I was told that the boundary line on the east that encompassed, well, I guess that would be the west, that encompassed half of the land base, that the boundary line encompassed half of the land base under the Colorado River. And the question is, didn't this give us rights to the Colorado River, regardless of, what happens with the court case? Or, well, she says, regardless of paper or wet rights. And then when did our boundaries change? Or does this not even matter when we are fighting for paper or wet water rights? So
probably more a question for you, AG, than me, but feel free.
Yeah. Well, I mean, in the settlement context, we're having that conversation right now, and we're not really drilling down into that level of detail. People are coming to the table with an understanding of the scope of rights, and that is driving the direction of the settlement. But we're not essentially discussing those aspects necessarily or establishing those. In the adjudication context, that's where you might do something like that. But our current adjudication with respect to Arizona rights is only relating to the LCR basin. And our Supreme Court case was all about trying to get some movement on our main stem claims. It's been, as Paul went through the lengthy history, that's not something that the feds have invited in the past or been open to in terms of having certainly any kind of legal resolution on the scope of claims in a court context. Doesn't really answer the question.
Well, I mean, it's interesting because at the oral argument, the representative for the Solicitor General's office, which of course represents the United States before the Supreme Court, and I forget which justice, it may have been Gorsuch, asked him the question directly: does the Navajo Nation have a right to the Colorado River? Right? And the person, Fred Liu, declined to answer the question. We have to, and so it's of course been a matter of frustration, as you are aware, AG, that the United States, for whatever reason, at least the Solicitor General's office, right, of course, was a very unique office, has declined to affirmatively state once and for all that, in fact, regardless of where the boundary is, regardless of whether the river's here and the cliff is here and, it's so expensive and PIA and this and that and the other thing, we have a reserved water right to the main stem Colorado River, right? I don't think we've ever wavered on our position, right, that we do. It's just the United States has not always been. And that's one of the things, as you know, that we worried about in this litigation, right? We thought it was only about breach of trust and whether the treaty gave the sufficient notice of a duty to the United States. But as you know, Arizona and those other interveners wanted the Supreme Court to shut the door, They wanted the Supreme Court to definitively state either we couldn't raise it at all, or we had to go through the Supreme Court original jurisdiction for Arizona v. California. So if we had a success, in addition to the groundwater, as you know, it's to prevent that. The door wasn't closed. In fact, it's wide open. As you and I both know, both Kavanaugh and Gorsuch said, well, the Navajo Nation can intervene, right, if they feel it appropriate to do so. To me, that was, an astonishing something they both agreed on, to say whatever attempt there was to utilize this case to shut down the nation's ability to raise a main stem Colorado River claim was unsuccessful. And yes, okay, we may have gotten a 5-4 decision that the treaty as treaty does not meet the now high threshold to establish an enforceable trust right in court. That's all it did. And everything else is on the table and continues to be on the table. And so we didn't lose anything, right, really, when it comes to the real issue, which is getting water to the Navajo people, right? I mean, that's my view. I assume, AG, you agree as well.
Yes, absolutely. And then we have another question from Carrie. What kind of rights do tribes have from the standpoint of ceremonial rights? And then she references the Colorado River and Salt Canyon, and that being a place to obtain ceremonial items. It's not really relating to the case necessarily. I mean, there are those rights, and people are exercising those rights now. I don't think we've ever had an instance where there's been interference, but certainly, like when there was the proposed hydro project for the mouth of the Little Colorado River, where it's the confluence is, there were a number of tribes that submitted comments, and they raised their ceremonial rights and interference with those as a reason to not proceed with the proposed project. And I don't think FERC has not issued those permits. I don't know exactly where things are with that application process, but.
I mean, I am sure, at least speaking for me, and I assume also the AG, if we are made aware, right, of interference with the rights of Navajo people to access those areas for ceremonial purposes, definitely let us know, because that is something that we will be interested in, because, one of the things we take seriously here, particularly under the current AG, is protecting the rights of the Navajo people in the way that we can at the Department of Justice, that the Navajo Nation government serves the Navajo people, and therefore we will utilize litigation when appropriate for the benefit, not of the government necessarily alone as government, but on behalf for the benefit of the rights of the Navajo people. I think we can say that we are definitely committed to that. And so if you hear of things and hear of interferences, let us know, and we will definitely talk to look into it and make the appropriate decisions as to what we can do.
And there are a number of federal laws that we can invoke to protect those rights. It just really kind of, I think it's often fact-based, especially if we're talking about ceremonial purposes. Yeah. So like Paul said, let us know if you experience interference, and we're happy to look at that situation.
Yeah.
And then we have another question from Spencer Willie. It says, do we have an opportunity to cancel water agreements with the states similar to the manner that Arizona did with the company that acquired water for growing crops that were exported from the valley to the Middle East? And he says they canceled those because it was not beneficial to the state. Could the nation cancel other water agreements like SRP and in-aquifer to maintain our own Navajo water use and purpose? I mean, at this time, we don't have agreements with SRP and or respecting the in-aquifer that would benefit anyone other than the Navajo Nation and the Navajo people. But in terms of whether we could cancel them, that's a complex question, if they existed. would probably involve authorizations by the Department of Interior or federal agencies. So it would depend on the nature of the agreement with the outside party. And hopefully, when we have a settlement, that will be something that we will be addressing in water use agreements. But even so, I think those agreements will primarily be, well, there really won't need to be an agreement because they'll be just serving Navajo communities with Navajo water. So, Paul, I don't know if you want to add anything to that.
No, not at all. I think that sums it up. I assume that's my neighbor, Spencer Willie, in Real Puerco, but just to right. One thing, AG, in the time that we have left, if there are no other specific questions, Bears Ears, I just wanted to mention briefly, right?
That'd be great. Yeah.
And as many of you know, of course, Obama created the Bears Ears Monument, Trump revoked it, and Biden reinstated it, right? There is still two I'm going to use the term we use here, litigations, 2 cases going on. There's still one in the District of Columbia still about whether President Trump at the time validly revoked the Obama monument. That has never been resolved. The other one came out of Utah, and that was the state of Utah, several counties of Utah, and several individuals in San Juan County challenging the Biden monument. That case was recently dismissed by the Federal District Court of Utah on a kind of technical issue about when can you sue the president. Those individuals, including the state of Utah government, appealed to the 10th Circuit Court of Appeals. We have just finished the briefing on our side. We aligned ourselves with the Native American Rights Fund and several other tribes in being an intervener, again, dropping down in the case because it was Utah versus Biden, and we came in as a party. So we filed our appellate brief about a week ago, and then we're just waiting to hear for the replies. There will presumably be oral argument in the next few months. It is entirely possible this will go all the way up to the U.S. Supreme Court, or it may be that a new president will simply revoke it again, and then we'll have 3 cases. So until Congress acts one way or the other, depending on the partisan effects of the election, it may be that we're going to continually be in a cycle of litigation involving how large the Bears Ears Monument should be. But in terms of ceremonial rights, as was discussed, one of the important things about the Obama proclamation and the Biden proclamation is it protects the rights of Navajos to continue to engage in those activities within the Bears Ears Monument. And to the extent that it's a larger monument, those protections are then in a much larger area than might necessarily be if the Trump reduction would be put into effect. So the Navajo Nation is a direct party. We continue to be very much involved in that case. And we did file a brief, and we will continue to update the Navajo people as to what happens with that. I would hope there would be a definitive resolution, but that's the thing with litigation. It can go on for a very long period of time without a definitive resolution. That's what we do here. That's what we do here, is continue to participate as best we can under the direction of the Attorney General. So just wanted to put that plug in for Bears Ears before we go.
Excellent. Well, thank you, Paul, for giving us our update. Aside from Bears Ears, any final thoughts you want to leave with listeners?
No, other than, this is really important, difficult work that we do our best. We're always happy to inform in whatever medium is appropriate to the Navajo people to update them because this affects them. It may not seem like it on a day-to-day basis, but these cases can have a tremendous effect. And I do believe personally that us doing it here in Window Rock on the Navajo Nation with the ability to talk to our elected officials and Navajo people is vitally important because we can provide you that direct access to discuss these important matters on the ground here on the nation. And so with that plug, I think the Department of Justice is doing a very important task that we will continue to do so and are very much happy to continue to inform the Navajo people as to what's going on. So that's it. Thank you.
Great. Wonderful. Well, thank you so much, Paul. And thank you to all of our listeners and viewers. Everyone have a great Friday, and we will see you next week. And just a heads up for next week, we're going to get updates on the recent amendments to the Navajo, I think it's the Navajo Procurement Act. Paul, am I misspeaking? Do you recall? I'm pretty sure it's the Navajo Procurement Act, but it might be the Navajo Business Opportunity Act. So we'll have a flyer out next week, and we'll provide that clarification then. But that's something that our Economic and Community Development Unit (AAG) has been working on quite a bit in the wind down to 2023, and so it'll be wonderful to get that update from her. And hopefully you all are enjoying these informational sessions. We want to make sure that what we're doing at the Department of Justice is accessible to the public. You guys get a better sense for the information that we have access to here, especially as it relates to your day-to-day lives. So thank you, everyone. Have a great rest of your day and a wonderful weekend. Yeah.